Good evening. So tonight's lecture is on the California legislative process. Last time we talked about the California State Legislature as an institution. Tonight we are covering the process by which legislation travels through that institution. Now, as you can probably imagine, we can look at it pretty simplistically because the bicameral California legislature operates similar to the bicameral Congress. A bill gets introduced, a bill is considered by, for example, a House committee, and then the floor, and then the Senate committee and the Senate floor, and then on to the president. That is, in its most simplistic terms, the legislative process, both at the federal and the state level. Now, we know that there are a tremendous amount of nuances in that process. And while we don't have time to get into all the gory details of the legislative process, we can probably spend an entire semester on it. We are going to delve into a little bit of the subtleties. We are dealing, of course, with one of the bodies of law. We have the Constitution, we have the statutes enacted by the legislature or by the people by initiative, regulations by the executive branch. So, of course, the legislative process is what the legislature does. And in Article 4, dealing with the legislature and lawmaking, in Section 8A1, it has a famous saying, at least to me, which is the legislature may make no law except by statute and may enact no statute except by bill. And so really, in a nutshell, that tells you what's happening. The legislature, when it engages in its lawmaking power, it enacts a statute. And the only way it can enact a statute is by a bill. Now, there are two other legislative measures, constitutional amendments. Obviously, those are placing measures before the voters to amend or add provisions to the California Constitution. The resolutions are all generally statements or expressions of the legislature. Note that in some states, a resolution can in fact enact a law. In California, they cannot. That is because of the Constitution there in Article 4, Section 8. So we have in California a bill, a piece of legislation. One important distinction between the federal and state level. At the federal level, the sponsor is the name of the congressperson, the member of Congress, the representative, the U.S. House member, or the U.S. senator. In California, instead, we say that the senator, the state senator, or the state assemblyman, whose name is on the bill, is the author. It is authored by that assembly member or members or by a senator or senators. We also use the term sponsor, but it is not the author like at the federal level. Sponsor instead means the individual or the group who suggested or recommended the bill to that senator or assembly member. So the individual, the group, who is behind it. And those sponsors are disclosed. They are identified on bill analyses and often floor analyses as the sponsor, or where there are multiple sponsors, then they're listed as co-sponsors of the bill. And so there is public disclosure of who that individual or group is. Now, a bill, whether it is, just somebody's idea, I'd like to do a tax credit for, building homeless shelters, or somebody comes forth with a fully fleshed out proposal in the form of a bill. Those submissions still have to go to OLC, the Office of Legislative Counsel, sometimes referred to as the Legislative Counsel Bureau. Now, at the federal level, both houses, so the 100 senators have a Senate Office of Legislative Counsel, and the 435 House members have a House Legislative Counsel. In California, the Office of Legislative Counsel and their roughly 80 to 85 attorneys there work with both houses of the legislature. At the federal level, having something drafted by legislative council is voluntary. On the other hand, in California's legislature, a bill cannot be introduced nor an amendment made to any bill or legislative measure, resolutions, constitutional amendments. They cannot even be introduced unless they are in quote unquote legislative council form. So again, whether you have a bill idea in concept or you have a fully drafted bill, it still has to go to the attorneys in legislative council for any full drafting or any editing of that measure. Now, once legislative council attorneys finalizes the bill language, then the bill is introduced. And that is the first public reading of 3 that the Constitution requires. Now, the 3 readings can be suspended. That is very rare. It means that something has to be urgently considered at the beginning of the year, of the 2-year session. Last time that happened was in January 2024 for one single bill. So that's the first reading when it's introduced. And then the bill language is turned over to the state printer, OSP, the Office of State Printing. And hard copies are produced every day of introduced bills and, of course, throughout the session of amended bills. And those are also placed on the internet, the LegInfo website. Another constitutional requirement is the 30-day in print rule. Maybe this was from the Pony Express days, but it remains in the California Constitution. And what it says is that there can't be any official action like a committee hearing or a vote until 30 days have expired. So on the 31st day in print, that is when a bill can actually be officially considered in the California legislature. Just like the 3 readings requirement in the Constitution, the 30 days in print requirement can also be waived by a supermajority vote.
Chris,
Following the bill's introduction, the Rules Committee of each House, so the Assembly Rules Committee for an AB or the Senate Rules Committee for an SB, of course, decides where is that bill going to be referred, what policy committee. And in the Assembly, there are currently 32 standing committees, including a Budget and Appropriations Committee for fiscal bills. And in the State Senate, there are 23 standing committees, including an Appropriations and Budget Committee. That means that there are 21 Senate policy committees and 30 Assembly policy committees. From business and professions to transportation to judiciary and labor, education, and then the Assembly has some committees that don't exist in the Senate because their jurisdiction is encapsulated in one of the other committees. There's a higher education committee in addition to education. There's a privacy and consumer protection committee as opposed to privacy is done in the Judiciary Committee in the Senate, for example. So the Rules Committee will refer a bill to at least one policy committee and potentially 2, or in rare occasions, 3 policy committees. And we affectionately call those extra committees a dual referral or double referred or a triple referral. Again, that's generally very rare that 3 policy committees in either house would consider a bill. Now, those referrals by the Rules Committee do not include a referral to, or a re-referral technically, to either Fiscal Committee, which we call the Appropriations Committee, named after their federal counterparts. But it's the budget committees, Assembly Budget Committee and Senate Budget and Fiscal Review Committee, that you may recall when we covered the state budget. Those are the ones that actually do the appropriating in the budget. The appropriations committees themselves are the fiscal committee. So you'll note when you take a look at an actual bill that after a description by legislative counsel, it's called Legislative Counsel's Digest. It explains in independent, nonpartisan terms what is existing law and what does this bill attempt to do. Thereafter, there are four keys: the vote, whether or not the bill contains an appropriation, then fiscal committee, meaning will it be re-referred to the fiscal committee after the policy committee? And then lastly, local program. Does the state mandate on local government or school districts, do they have some sort of mandated program or mandated level of service for them to do? Those are called the digest keys. So when the fiscal committee key says yes, then after the policy committees finish their work, the bill goes to the fiscal committee, i.e. appropriations in the Assembly and the Senate, and then they consider the fiscal aspects of that bill. Now, as you can imagine, like at the federal level, legislators can't be experts in every area, so they naturally serve on a number of these policy committees. On average, 5 to 6 in each house. Republicans usually serve on more. There are fewer of them. Like in Congress, the majority party is the chair and the minority party is the vice chair. And so again, in both houses, due to them representing about a quarter of the total number of assembly members and senators in each house, Republicans often serve as a vice chair on more than one committee in either the Assembly or the Senate. Once the bill gets referred to committee, then the committee has control of that bill. And although they don't really exercise that absolute power, they do have it. In other words, once it's in their jurisdiction, they can decide when to set it. For a hearing, they can decide what amendments will or will not go into it. Again, that sort of absolute power is rarely exercised. The committees work cooperatively or collaboratively with the Senate author or the Assembly author of that bill. Whether you're in your house of origin or in your second or the other house, they generally all work, set a bill when the author wants to hear it, take the amendments that the author wants to do. Sometimes there are hostile amendments, but not often. Each of those committees, both policy and fiscal, have one or more committee consultants. On average, they have three. There are a handful of committees that have just a single consultant. And then the budget committees in both houses and the fiscal committees in both houses have quite a few consultants, as many as 10 in some instances. And these committee consultants, of course, their main task is to analyze the bill that is going before the committee. So they'll research legal and policy questions that the bill presents. What does existing law do or not do? What does this bill propose to do? What are the arguments in favor? What are the arguments against? And then ultimately, their research and analysis gets drafted up and becomes a public document, the committee analysis of the bill. And that is provided for two parties. One, the legislators on that committee who will hear and vote on the bill, and then, of course, for the public itself. And these are forever documents. Since 1993, all analyses are available on the LegInfo website. And those pre-1993, so 92 and earlier, are available at the state archives in Sacramento, which you can access in person or request them to do a research request for you. The analysis, again, generally has four main parts. What is the current law? How does this bill propose to change current law? What are the author's main arguments? And then what are the proponent's arguments and the opponent's arguments? Once that analysis is out and the bill is set for hearing, then of course we have an actual bill hearing. And at those hearings of the policy committees in either house, it follows the same order of presentation. The author of the bill presents his or her measure to their colleagues or to the other house, depending on where they're presenting in the house of origin or in the second house. And then they are followed by generally two main witnesses in support, followed by what we affectionately call the Me Too witnesses. Me Too meaning that me too, I also support the bill. And those people don't get to offer substantive testimony. They merely state their name, their affiliation, and that they support the bill. Then they turn to the opposition. And the opposition generally gets two main witnesses. Often they are limited to 2 minutes each. There are some committees in which together they can have 5, 8, or maximum 10 minutes, but that's rare. Most are two, for, two, and against for 2 minutes each. After the two main principal opposition witnesses, of course, come the opposition Me Too witnesses. And so they also will identify themselves by name, affiliation, and that they oppose the bill. After that, the committee members may or may not ask questions of the author, and perhaps the main witnesses in support or in opposition. They may have some debate amongst themselves as committee members. And then ultimately, they are presented with whether or not they want to amend the bill, pass the bill as is, or defeat or not support the bill. Usually, committee chairs, in most instances, offer a recommendation to their colleagues, which is usually followed in most instances. In other words, a Democratic chair of a committee with a majority of Democrats sitting on that committee are generally going to make a recommendation to support or oppose a bill, and that Democratic majority on the committee will most likely follow suit what that recommendation is by the committee chair. Remember, in terms of amendments, they can either be author's amendments or committee's amendments. The author's amendments are obviously what the author wants. Committees can make either friendly, meaning they're acceptable to the author, or hostile, meaning they are not acceptable to the author. It is rare today that hostile amendments are put into a bill. It happens on occasion, but most often an author either accepts the committee's recommended amendments and the bill passes, or they reject them and take their chances. Most often, the bill will not likely move forward if the committee's recommended amendments are not taken. So again, you've basically got, insufficient votes to pass the bill. So it's either defeated outright, or they may not take it to a vote, and so it's held in committee. Or you have a straight, they call it a straight do pass, meaning the bill passes on to the next committee or to the floor, a do pass motion, or do pass as amended, meaning that when the bill exits that committee, it will be amended before it is heard by the next committee or on the floor. Those actions are officially reported to the floor, and the floor actually then technically makes or accepts the recommendations by that committee. Now, after passage from the policy committee, a bill will go to second reading, and they are read the second time either because they passed without amendments or they passed with amendments. If they have to go to a second policy committee or they get re-referred to the fiscal committee, then they'll leave second reading kind of being on the floor and they'll go back to one or more committees. So each time you pass the committee, whether you're amended or not, you go to second reading. You stay on second reading and go to third reading if you don't have to go to any more committees. But if you have to go to another committee, then when you pass the one committee, you go to second reading, and then they send it to the next committee, and then back to the floor again, and then maybe to another committee, and back to the floor again. So that's the second required reading under the Constitution. A bill could have multiple second readings. It might go to more than one committee, a policy and fiscal committee, that's two. It could go to two policy committees and a fiscal committee, that could be three. So it could be subject to second reading 3 times. For third reading, a bill is read the third time when it is about to be taken up by the author in the House of Origin, so an assembly bill on the assembly floor by the assembly author, or in the second house when a senator takes up that assembly bill on behalf of the assembly member. Because, of course, assembly members aren't members of the Senate and senators aren't members of the assembly. So while they can present in each other's committees, they cannot appear on the floor because they are not a member of that floor. So they can't present their own bills in the other house. Instead, they have to ask a colleague from the other house to basically be an author for purposes of presenting the bill. Today, we call them floor managers. In the old days, 20 years ago, we used to refer to them as floor jockeys, but now they are floor managers, and they handle potential amendments. They present the bill on behalf of the author. They debate it with their colleagues. They answer questions, and they ultimately lobby for passage of that bill. Now, if the bill, of course, is approved in its house of origin, then it has to repeat the process in that second house. If a bill is defeated along the way in committee or on the floor, one reconsideration can be asked for and granted. So everyone, in theory, could get a second bite at the apple. But in most cases, bills require a simple majority in both houses. That's 21 of the 40 senators and 41 of the 80 assembly members. Now, there are some measures, most commonly those with an urgency clause, meaning that they take effect immediately upon the governor's signature, require a supermajority of 2/3. That's 27 votes in the Senate and 54 votes in the Assembly. So not only urgency clauses, but bond acts. So last November of 2024, we, the voters, approved two $10 billion bond issuances by the state of California, meaning those bonds are backed by the state's general fund where taxpayers pay in. 10 billion for school facilities and 10 billion for climate change programs. Constitutional amendments, remember those don't require action by the governor, just a 2/3 supermajority vote by the Senate and the Assembly, and then they go to the voters. There are also some bills that amend voter-approved initiatives that created statutes. So popular ones are the Political Reform Act of 1974 or the Insurance Rate Regulation in 1988. Those require a 2/3 vote for the legislature to amend them. So you don't have to go back to the voters to amend those statutes that the voters enacted by initiative, because the initiative themselves say, hey, legislature, you have authority to amend them, but you have to do it by a supermajority, by a 2/3 vote. So again, we repeat the process. If both houses pass the bill, then obviously the next and final step is the governor's office for final action. Yes, if the Senate or the Assembly makes amendments that the other house, the House of Origin, so assembly bills that were amended in the Senate, Senate bills in the Senate for assembly amendments. If they don't agree with what the other house did, they can non-concur, which requires the creation of a conference committee. We don't use conference committees anymore in California, not even for the budget these days. In a nutshell, the legislature with super duper Democratic majorities work any differences of opinion out before the House returns, I'm sorry, before the second House returns the bill back to its House of origin. In other words, the Senate committees are not going to make changes, or if they do make changes to a bill, they will have been agreed to by their assembly counterparts. And likewise, the assembly isn't going to make changes to a Senate bill without the approval of the Senate folks. And that's why we don't have non-concurrence votes in the legislature. Instead, they just get taken up for concurrence, and 99% of the time they're concurred in and sent to the governor's desk. Otherwise, they end up getting defeated, is the only other real option. We don't do conference committees. When the bill hits the governor's office, the general rule for 8 months out of the year is he or she only has 12 days to act. And the California Constitution, as you may recall from the first class, gives the governor three options: sign the bill, in which case it becomes a statute; veto the bill, return it without a signature, then it's not a statute unless overridden; or allow the bill to become law without the governor's signature. And that is an option. Governor Brown, in his last 8 years, the 2.0 version of Governor Jerry Brown, I think he did it 3 or 4 times. Governor Davis did it 10 or 12 times. Governor Newsom, in his first 7 years in office, has not done that a single time. He's acted on all 6,000 plus bills that have reached his desk, either signing or vetoing them. At the end of session, knowing that hundreds of bills, in fact, upwards of close to 1,000 in some years, bills get to the governor's desk, and the governor needs sufficient time to consider those. And so at that time, we extend it to 30 days rather than 12 days for the governor to consider those hundreds of bills. Now, there's one final ministerial step that the governor's office does in conjunction with the Secretary of State, which is the secretary gives a chapter number to every bill. In each year of the session, so 2025 goes 1 through, he signed 917 or 914 regular sessions. So the last chaptered bill was 914. In 2026, the governor will start at 1 again and work his way up. So each year of the session, we go back to 1. The default rule is that bills become effective on January 1 following the year of enactment, except for 4 types of bills, including urgency and budget-related bills. And those take effect immediately when they're signed. So yes, we do have some bills that took effect in August, September, and October when the governor actually signed them, as opposed to January the 1st. Most governors veto about 15 to 17%. Governor Schwarzenegger in the last 50 years had the highest. He went as high as 35% one year. Jerry Brown in the 70s one year only did 1%. But on average, over the last 4 decades, in checking back, it's about 17% overall. This year, Governor Newsom did 13.4%. He did almost 16% last year in 2024. So, of course, gubernatorial action is the last step in the California legislative process. Now, what I want to do is, like the prior night on the institution, as we've talked about it generally, is to actually go to Article 4 of the Constitution and note some of the unique provisions, because when I'm often asked by lobbyists, staff, the media, and others about certain procedural requirements, I generally say that's because the Constitution requires it. Yes, there are some provisions in the California Government Code in statute dictating the process. And there are others that are in the joint rules. And there are some rules that are in the assembly rules, in the Senate rules. And then we have some very minor rules that are actually adopted by the individual committees, and those are in committee rules. And the legislature has that authority to dictate its proceedings other than those in the Constitution and Government Code, because in Article 4, Section 7A, I read it the other night. First, it says each house chooses its officers, right? That's how we have a speaker and a pro tem and majority leaders and others, but also that they may adopt rules for its proceedings. So that's why we have the joint rules, the Senate and Assembly rules, and ultimately committee rules as well. So the first one that I mentioned, of course, is that 3 readings and the 30-day in print rule. The 31st day in print can be waived with a 3/4 vote. And of course, that happens in just the 2 houses, just the house in which it was introduced. So the assembly must take that vote, or the Senate must take that vote if they're going to act on the bill before that 31st day. That is a rarity, once, maybe twice every 2-year session, but it is very rare. The 3 readings actually have to occur on 3 separate days. And in 99% of the cases, it does. In the rare cases where they have to expedite consideration, they can waive that too by a 2/3 vote. So the 30-day in print rule, 3/4 vote, they can waive it away. They can dispense with the rule. The 3 readings on 3 separate days can be dispensed with a 2/3 vote. One of the most well-known rules, it was imposed by the voters just in 2016, and that's the so-called 72-hour in print rule. That says that no bill can be voted on until its final amended version has been in print and published on the internet in that final form for at least 72 hours. And so that is an important procedural rule, particularly at the end of session. So in the old days, prior to 2016, or 2016 and prior to that, because it took effect for 2017's session, you could have last minute gut and amends on the very final day of the legislative session. There were years where legislators, staff, and lobbyists were simply waiting around in the final hours of session, just waiting for bills to be drafted and voted upon. The voters did away with that by that 72-hour in print rule. The other item here is no bill may be passed unless by roll call vote entered in the journal, a majority of the members of each house concurs. So then, of course, you ask about the higher vote thresholds, and that's because those have been imposed by voter initiative. So the default, of course, is majority vote, 21 senators, 41 assembly members, at least that to get a bill to the governor's desk. But a higher vote threshold is allowed either in statute by the voters enactment or in other areas of the Constitution. The most famous one probably being Prop 13 in 1978 added Article 13A, Section 3, that requires a 2/3 vote of each house of the legislature to impose a tax increase on the taxpayers of this state. There's also that effective date. Remember, January 1 is the default effective date of bills with 4 exceptions. And then for a special session, a bill becomes effective on the 91st day after the session adjourns. The magic notion of the 91st day is that a bill is subject to a referendum. You may recall from an earlier lecture on direct democracy. They have 90 days from the date of enactment to gather the necessary signatures to stay that statute, put it on hold, and get it to the voters at the next scheduled election. So that's why when the special session adjourns, the 90-day clock starts ticking in case somebody wanted to pursue a referendum on a special session bill. And on the 91st day, assuming there's no referendum, that special session bill takes effect. So January 1's the default, unless it's one of the four specified types of bills: calling an election, tax levies, which are changes to the tax law generally, not just tax increases, the budget bills, and urgency clause statutes. Those are the four exceptions. Those take effect immediately. Everything else is January 1 in a regular session. In a special session, of course, we have that 91st day. They also explain an urgency statute and how it's only available in certain instances. And in fact, there are certain types of bills, like creating an office or changing the salary of an office or the duties of an office or creating any new rights. Those cannot be done by an urgency statute. They have to be done by a regular bill. And also, 2 votes are required for an urgency statute. The first is a vote on the urgency and then a vote on the bill itself. So what you'll hear on the floor of the Assembly or the floor of the Senate is, after the vote is taken, again, at least 54 Assembly votes and 27 Senate votes, is you'll hear, ayes 55, noes 10 on the urgency, ayes 55, noes 10 on the bill. I often get a question: why do they announce the same vote twice? The Constitution requires it. In each house, the section, the urgency section, and the bill shall be passed separately, each by roll call vote entered in the journal, 2/3 of the membership concurring. So why do they announce the same vote for both the urgency and the bill itself? Because the Constitution requires it. Okay. We also have the all-important single subject rule in legislation. So just like an initiative can only embrace but one subject, so too can a statute. So a bill can only embrace but one subject. And of course, it's in the title. So a very important title relating to transportation or taxation or something like that. That's first an important procedural rule, is that, and also a drafting rule, of course, the single subject. We also have the reenactment rule, which is a wonderful thing. If you've seen some states, but particularly the federal government, a bill, they just put in what the change is. Like amend, section 100 subdivision C to add in the classroom. And that's all you see in the bill. What do you have to do? You have to go find that federal code section and then find it and, like, okay, so we're adding on in the classroom. Oh, right here. Okay, now I know what we're talking about. In California, whether you change a single word or add a comma, delete a comma, add entire paragraphs or additional sentences to an existing code section, you reenact the whole code section along with your one or multiple changes. We call that the reenactment rule. And that's why in a bill, you get to see the whole statute, even with the one word change. And that's because the Constitution requires it. But again, for somebody who is trying to understand what a bill will do, etc., that's extremely valuable, as you can probably imagine. Those are in section 9, and section 10 is bills going to the governor. Again, signature, veto, or allow the bill to become law without the governor's signature. We have the 12-day generally. We also have the 30-day rule at the end of session, etc. We also have what are called 2-year bills, but the joint rules of the Assembly and Senate call them carryover bills. And that's because in 10C it says any bill introduced during the first year, 2025, the odd numbered or first year, that has not been passed by the House of Origin by January 31st of the second calendar year of the biennium may no longer be acted on by the House. So basically, in the first or odd numbered year, 2025, for example, all the bills introduced earlier this year, if they didn't make it through to the governor's desk, they can be considered next year as well. The one requirement in the Constitution is that they pass out of their House of Origin by January 31st, and then they can continue on their merry way. The other interesting thing is that in the second or even numbered year, 2026, we're coming up on, that's when everyone says the legislature adjourns August 31st. Well, if you search Article 4 for August 31, you won't find it. So how do they always adjourn August 31st? Well, it says that no bill may be passed by either house on or after September 1st of the even numbered year, with 5 exceptions. And they're the bills that take effect immediately: calling an election, tax levies, budget bills, urgency bills, and then bills that were vetoed. So those are like less than 1% of all bills. So when 99% of the bills by the Constitution cannot be passed on or after September 1, it means they got to be passed by August 31st, and therefore they adjourn in the second year by August 31st at midnight, because with those 5 specified exceptions, just a handful, maybe 5 or 10 bills at most, they can't consider any other bill after midnight on August the 31st. So that's the, benefit of that provision. The legislature is allowed to create committees to conduct their work. In fact, the Constitution provides it by resolution. So they adopt House resolutions to adopt the Assembly rules and the Senate rules, and that's where they identify by name and create those 32 Assembly committees and 23 Senate committees. The committees are also allowed to ascertain facts and make recommendations to the legislature on a subject within the scope of legislative control. So that's their power in essence to, to investigate, to have oversight, etc. In section 12, we deal with the budget, which we've talked about, including the governor's obligation to submit the Jan 10 budget, which must be balanced. The legislature has to balance the budget. And here in 12E is where the voters also added in 2010 a change. California used to be, up until 2010, one of 3 states that required a 2/3 vote, a supermajority, to pass the state budget. Now we've joined the most other states in requiring a mere majority vote, and that's because the voters added 12D, basically saying that, or 12E, sorry, that it only required the budget bill and the related budget bills, junior and trailer bills, only require a majority of the membership of each house in order to go to the governor, and also to take effect immediately. So it's a twofer. Not only is it a majority vote now, not 2/3, but those bills also take effect without, for example, an urgency clause provision. And so, that's also something to be aware of. There are in the Constitution, as we talked about the legislature, about those conflict of interest and gift and honorarium prohibitions that all impact the process of the legislature. In section 16, all bills, all statutes are supposed to be of a general nature, but some local or special statutes can be utilized. Those are most often where something is just applicable, say in 1 or 2 counties or cities, or when the legislature wants to try a so-called pilot project. That's when you use that local or special statute rather than a general statute that applies statewide. As I mentioned previously, the impeachment power is with the Assembly. Impeachments are tried by the Senate. There is a couple of other interesting provisions of the state constitution applicable to the process. It also sort of plays into drafting as well, but that is the legislature can't authorize lotteries. They can regulate horse racing, that's in the Constitution. They can authorize cities and counties to provide bingo games, but only for charitable purposes. Otherwise, they can't authorize any sort of casino style gaming. They also are required, believe it or not, to divide the state into fish and game districts. Um, there's also an interesting provision at the start of the 2-year session and at the end of the 2-year session. Sometimes people get frustrated at the end of the 2-year session. It's often just past midnight on September 1. They finish their business. And the 4 legislative leaders, the Senate pro tem, the Senate Republican leader, the Assembly Speaker, and the Assembly Republican leader, get up and talk about all the things that they achieved and all that. And people are like, I just want to go home. Why are they saying this? Well, Section 22 of Article 4 actually requires it. It says that at the convening of the session and at the end of the session, that the 4 leaders have to report to their houses about their proposed goals and objectives. And then at the close, what progress they made towards meeting those goals and objectives. So that's actually why they stand up on the floor and make those remarks to their colleagues, again, when everybody is exhausted and wants to go home. So that is an overview of the California legislative process. Obviously not exhaustive. There are lots of detailed aspects of it, but that's probably a sufficient amount for you to generally understand how statutes get enacted by bills in the California legislature. Let me know if you have any questions.
Chris, to go back real quick on, so let's say a senator has an idea and do they just take that idea to the attorneys and the attorneys draft all the language, or do they start with any type of language that they hand off to the attorneys?
They can do either way. Ledge counsel, you can go to an attorney at Ledge Counsel and say, I have this idea, draft me a bill to do X, and that's it.
Okay.
And they'll they'll work with the author and say, well, to whom do you want this to apply? When, they'll ask questions, but you could just go to the attorneys with a concept.
Okay.
The author, their staff, or an outside sponsor, an outside interest group could come with a fully drafted bill. Please amend Government Code Section 1234 to do the following. And it's all written out. Council will review it, see if they like the language, if it makes sense. Does it comport with our drafting rules in California, et cetera, et cetera. And then they'll give it back to the author in a form that they can introduce in it. But it's soup to nuts with the attorneys at Ledge Counsel. Broad concept or an already drafted bill, you can give them anything and they will work with it.
Interesting. Okay. Thank you.
You bet. And we'll get into more of that in the class on legislative drafting later in this session. So, okay, upcoming are some guest lectures next week. So we have a series of them coming up on not just the legislature and the legislative process, but also later on legislative drafting and statutory interpretation. Have a good evening.